My name is Akiva Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. Today we're continuing our video series designed to educate and inform the public, so please subscribe to our channel. When we talk about divorces, there's a lot of issues that come up. You've got your custody, your parenting time, your child support. There may be debts, Visa, MasterCard, IRS, medical bills. There might be assets to divide, such as stocks and bonds, mutual funds, money in the bank, 401k, IRA, all of these things. But in addition to those things, there might be hard assets. There might be, some kind of heirlooms, coin collections, pictures on the wall. There might be homes and cars and motorcycles, boats, all these kinds of things. And the question that commonly comes up is, how does the court figure out who gets what? Well, you got a boat, both people want it. How does the court figure it out? Well, there's a lot of things that the court does. And there are different judges that handle it different ways. So, for example, let's say both parties want an item that has a monthly payment attached to it, like a boat. A boat not only has a monthly payment for financing it, it has, maintenance payments, and the boat has to be dry wrapped, and the boat has to be stored somewhere when it's pulled out of the water after the season, and there's all that maintenance and stuff like that. The court may look at that and say, well, you know what? This asset I'm going to allocate to this person because they can afford to maintain the boat. The other person can't afford it. Now, you might say, well, in doing so, you're sticking one person with all the bills of that item. True. But at the same time, what the court is going to do is going to find out what the value of that is. It's worth $50,000. Then the court is going to make an adjustment so that the allocation is equal. So the court may give a $50,000 item to one person, give them the boat. But if the court is likewise giving them a $20,000 expense, the other assets and liabilities even that out so that it's fair. The court might also reason, you know what? I'm giving him the boat because he's got the higher salary. If he doesn't want the boat and the expense, let him sell it. He can sell it, get rid of the expense, get rid of the item, and that's up to him. But that's how I'm going to do it. That's how some courts may do it. Another way that the court might do it is the court might divide up certain key assets. Like, let's say, you take this car, you take that car. But on all the other things, the smaller items, the court might say that the parties have to agree within themselves. And if they cannot agree, then an arbitrator will be appointed to determine that. But the court itself might not get involved in the nitty-gritty of you take that set of dishes and you take that set of dishes. So that's a possibility. The third possibility, and frankly, the possibility that probably makes the most sense, is that the parties are given a certain amount of time to agree on certain things. If not, the court's not, in the auction business. The court's in the liquidation business, okay? If these parties cannot agree on these 10 items, who gets what? The court has every right to appoint a receiver to order that stuff sold, to split the money after the costs of the sale, and the costs of the receiver, presumably, are paid out of that stuff. In other words, the court will hold a garage sale, basically, and sell all your valuable items that you can't part with at bargain basement prices, which means a $100 item might be sold for $20. And if that's the case, there'll be precious little realized out of that. So you have to understand, you got to figure out who you're dealing with. If this comes up, you got to speak to your lawyer and you got to find out, well, what will the judge likely do based on experience, based on his history? What's he going to do about our stuff? Is he going to have a fire sale? If he's going to have a fire sale, then we might as well work it out ourselves. If he's likely to say, okay, you take these and I'll take these, maybe that's the way to go. I don't know if my message is coming clear, but if it's not, let me put it to you this way. Rather than go through that, it behooves you to sit down with either through your attorneys or directly and work out who's getting what, okay? Because I assure you, if you leave it up to the guy in the black robe, he will somehow find a way to make it unacceptable to everybody. It'll be a quick way, it'll be a fire sale way, and a lot of money might well be lost doing it that way. Now, if you have any questions about your case, reach out, and we'll be glad to help you out.